All right, welcome everyone. It's another Rains-Feldman Cyber Liability Update with Eric and Steve and Scott. And I'm totally unprepared today, guys. I don't know what we're going to talk about, but Scott, I think you have a topic in mind, so let's hear it. What's going on in the world of cyber liability and litigation and liability and the law and all that good stuff?
All right, that's quite a broad range of things you just mentioned. So we're going to talk today about a topic that's interesting, hopefully. It's the trade secret law when applied to the internet. Namely, we just had a case that we won, we were defending, got the whole case thrown out, and it involved trade secrets where one could scrape the internet and find out the allegedly protected information. Here it was the client list of the defendant and the client list plaintiff, and our client, the defendant, had allegedly found the client list and then contacted the customers, and our client argued that he had obtained the information legally by viewing it on the internet because they were publicly available. If you scrape the internet, you would see who the customers are, find out the URLs, and then find out who the customers were. And so that was an issue that was addressed, and while there's not been a major appellate decision that's addressed this issue, most of the lower courts have found that if something is publicly identifiable on the internet, and it can be found only through scraping the internet, so you can't just, Joe Schmo can't go on the internet and find out the information, find out
In
the
other
whole
words,
list.
you can't just do some Googling and put together the whole list. You have to have some sort of technological apparatus at your disposal.
Correct. That's where the cases have dealt with, and the trial courts that have dealt with this have found that if it's available to users via internet scraping, that it is publicly available enough that it's not trade secret protectable.
I see. So if you're someone who wants to collect information from a competitor, for example, and you put together an algorithm to go out there online and scrape all that information up, and then you get sued by your competitor for a trade secret misappropriation, odds are that you'll win the case or get the court to toss it out. Is that what you're saying?
Yeah, that's what I'm saying. Even though an average person would have a hard time creating that algorithm and performing such an operation, because it can be done, the courts have found that the information is readily ascertainable. That's the test that's used most places. California, it's a little bit of a controversy, but still readily ascertainable is still likely the rule in California. And so if something is readily ascertainable, it's not a trade secret. You can't, if Coca-Cola were to make their recipe available in a readily ascertainable manner, the ingredients to Coca-Cola would no longer be protected. Anybody could go take that secret and go ahead and use the recipe for Coca-Cola. That said, so people need to be careful. I think people need to be careful who own trade secrets, how it can be viewed on the internet, whether it can be obtained by scraping or relatively, I won't say easy methods, but methods that a sophisticated computer user can implement to obtain the secret.
Okay, so in today's day and age of the internet and competition, the message is to be careful what you put out there, correct? Because there are smart people out there who can construct algorithms and find out information, whether it's your customer list. I can think of this applying to pricing information. You could create an algorithm to go out into various markets and figure out your competitors' pricing models. And I could see scenarios where companies have their employees disclosing customer lists or pricing information on a website like LinkedIn, for example. So one of the things that companies need to remember is that if it's online, odds are that it's not a trade secret.
Yeah, I mean, the traditional case with employees is that you can have the employees sign a non-disclosure agreement, and you're generally protected then, because if someone were to buy a list from an employee who signed an NDA, both the person who purchased it and the employee are liable. You can go to court, you can get an injunction, but the problem is you can do all that, have an airtight agreement. If the information is available in a way that someone could scrape the internet, then it doesn't matter how great your contracts were and how much your contract attorneys love it.
So if you're defending one of these trade secrets cases, Steve, I know we had an informative video a few weeks ago about getting your attorney's fees if the case is specious. And
Right.
specious, I think, is a legal term that equates to bullshit. I think we established that on our prior video. So if you're a defendant in a trade secrets case and you've gone out and you've gathered a bunch of information from your competitor or former employer and they sue you, if your lawyers are able to explain in a coherent fashion to the court how this information was obtained through algorithms or some sort of other scraping technology, then I believe that you can set yourself up to get your attorney's fees and demonstrate that it's a specious case to the court, because you walk into court and you say, Your Honor, anyone here right now can go online and find out this information. Right? That's kind of the bottom line.
That's the bottom line, but as I think we talked about the last time about the specious case, you want to make, not only do you need to be able to show that to the court at the end of the day when you get your win, when you show the court, hey, there is no secret here, it's out in the open for anybody that knows how to go looking for it. But you have to be able to point to the court and say, and not only that, we told them this. We told them this from day 1, at day 3, at day 5, all the way around along the case, saying there is nothing here. You don't have a case. You don't have trade secrets. And if they keep going, that's when the courts are most likely to give you your attorney's fees, because they might have brought a claim thinking, hey, we have these great agreements, like Scott was saying, that our employees aren't allowed to give out our customer list. So if you got our customer list and our employees are the only ones that have it, then there must be some violation here. We have contracts protecting this. We try to take care of it. They could bring that case, but once you point out to them, no, this isn't that secret. You have it on the internet. This is how we figured it out, and it's not a secret. Then the case is specious. They're pursuing a claim that there's no merit to anymore.
So that's a good point. So our last point, Scott, and that leads into my next point, is as the defense lawyers, it's important to get together with your client right away and drill down into exactly how they got this information so you can present that to the other side. And I think the one point that I'd like to make is, don't assume that the plaintiff knows what they're doing, understands technology, understands how they protect their own trade secrets. And time again in these cases, we've seen that the plaintiffs have absolutely no clue. And that's why so many of these trade secrets are specious. So I think the practice pointer is to get together with the client right away and really understand how they put together whatever the alleged trade secrets are, correct?
Correct. And I would say how they got it, how they could have gotten it, even if they didn't get it in that way. Try to figure out an ideal way that, even if your client got it in not the most best way possible, but there were other methods to obtain it that a court would find readily ascertainable, run with it. So,
all right. Well, I think good advice to our dozens of listeners. We'll catch everyone next time on the Rains-Feldman Cyber Liability Update.